Well, the treaties themselves and the nature of international law generally is that treaties are binding on countries, on the states. And so all of the major spacefaring nations are bound by the principles of the Outer Space Treaty, for example. Most of the major spacefaring nations have either now or are in the process of developing national laws, and those national laws are directed to bind the corporations of those particular countries. And so the treaties and the national laws essentially regulate different entities in space. To the greatest extent possible, countries should be matching the obligations that they put in their national laws with their international obligations under the treaties. But that doesn't necessarily always work. National laws, though, are generally there to regulate corporate activity in space, of which, of course, there's an increasing number of diverse activities. And so you have licensing arrangements, you have restrictions on technology transfer, you have confidential information, you have restrictions on certain types of activities in terms of national security. There are a whole range of issues. Obviously, as we move down the track towards the regulation of things like space tourism, national laws in countries like the United States and other countries will obviously need to focus on the regulatory aspects of space tourism. That is, things like safety and insurance and financial requirements and technical requirements, and a whole raft of things, air traffic control, that essentially we need to address as and when space tourism becomes a viable commercial activity.